Director Kathy Vidal for participating today. I also want to thank Ranking Member Tom Tillis and his staff for putting this hearing together on a consensus basis. This is our second hearing in 2 weeks, our third in 2 months. And Senator Tillis, you and your team continue to be great partners. There are, in fact, more to come. Director Kathy Vidal leads one of the largest intellectual property offices in the world, with more than 13,000 public servants, an annual budget of roughly $4 billion. Last year, the USPTO received about 460,000 new patent applications, a 1.5% increase over the number filed in 2021. The agency expects about 730,000 unexamined patent applications by the end of the year, an increase of roughly 40,000. Trademark application filings increased to over 940,000 in 21 before dropping a little bit back to more normal levels, around 800,000. The surge in 2021 caused an increase in application pendency, for which the agency has hired 92 trademark examiners to address. The USPTO has set and adjusted patent and trademark fees 6 times under its important fee-setting authority that the American Invents Act established in 2011. The agency is currently engaged in another round of adjustments to help it fulfill its mission of fostering innovation, competitiveness, and economic growth. U.S. global leadership and competitiveness depend on our ability to foster and protect innovation and creativity at home and abroad. Ensuring the predictability and the reliability of our patent system incentivizes innovation, rewards ingenuity, and improves our global competitiveness. Over the last decade, however, changes to our patent laws have chipped away at that system, threatening long-term investments in research and diminishing our stature on the global stage. To take one example, consider the introduction of the Patent Trial and Appeal Board, or PTAB, created by Congress in 2011. The PTAB, under proceedings that are known as AIA reviews that determine patent validity, have made it far easier to challenge an issued patent at the USPTO than in district courts. AIA reviews were intended to be a faster, cheaper alternative to district court patent litigation, but that's not exactly how it has worked out. 85% of PTAB reviews are also the subject of parallel patent litigation in federal court. This means patent owners have to defend their rights on 2 fronts at the same time. Rather than making litigation more streamlined, the PTAB system in its current form has just made it duplicative. These AIA reviews in the PTAB aren't being filed by small or innovative companies. Typically, large and well-established companies have filed thousands of AIA reviews against patents they've been accused of infringing, hoping to strip those patents away from their holders. Director Vidal, I support your recent efforts to use administrative rulemaking to address issues like these, to minimize inefficiencies, to provide additional protections to under-resourced inventors. I hope that you turn around the proposed rule quickly. In my view, however, Congress also needs to step up to the plate and act. That's why I've introduced, along with Senator Tillis and Senators Durbin and Hirono, the Prevail Act, a bill that would make some common sense reforms at the PTAB to protect inventors from costly, unnecessary, and duplicative proceedings. These common sense reforms include establishing a standing requirement to file an AIA review, limiting the number of challenges that can be brought against the same patent, and barring challengers from pursuing parallel challenges at the PTAB and in federal district court. I also remain concerned about the scope of subject matter that is eligible to be patented. Many witnesses appeared before this subcommittee over the last few months and have highlighted the uncertainty in our patent eligibility laws. Why does this matter? Critical technologies like medical diagnostics, software, and core AI are not eligible for patent protection here in the United States under our current law, but do qualify for protection in Europe and China. So I was happy to join Senator Tillis in introducing the Patent Eligibility Restoration Act last month. That bill will return eligibility to important inventions while resolving legitimate concerns over the patenting of ideas, discoveries of what already exists in nature, and social or cultural content that everyone agrees is beyond the scope of patent protection. I look forward to working with my colleague Tom Tillis and others, and with stakeholders to move Prevail and PARA through Congress to restore predictability and reliability to the patent grant. We also, last topic, need to be concerned about counterfeit goods from abroad. In 21, more than 80% of counterfeit goods entering the United States originated in China. Although we seized more than $3 billion of counterfeit goods at the border, that number amounts to only a fraction of the total value of counterfeits. These counterfeits can be unsafe and harm consumers. They're more than just fake sports gear or fake watches. As co-chair of the Congressional Trademark Caucus, along with Senator Grassley, I know how dangerous counterfeit goods can be. To give just one example, fake lithium batteries that have exploded or caught fire caused 70 deaths and more than 350,000 serious injuries just last year. I applaud the PTO's efforts under Director Vidal's leadership to teach younger Americans about the differences between real and fake products and the potential harms of purchasing counterfeit goods, the importance of buying real with the so-called Go for Real trademark campaign. The USPTO can't solve this problem alone, however, so I'm planning to soon reintroduce, along with Senator Tillis, the Shop Safe Act to protect consumers from harmful counterfeit goods sold online. I look forward to hearing from you, Director Vidal, to exploring your efforts to address these issues at the PTO and discussing the work we intend to do here in Congress to promote America's innovation economy. I'll introduce you in a moment, but first I want to turn it over to my ranking member and friend, Senator Tom Tillis.
Thank you, Mr. Chairman. It's been about 4 years, a little over, since we had a USPTO oversight hearing, so I welcome the opportunity to engage the USPTO, but I also have to say that you've already demonstrated a willingness to engage. Hearings and oversight are important, but I want to directly thank you for your leadership in the USPTO and your dedication to work in this agency and work with our offices. We get consistently good reports from our staff, and we also appreciate, it's not lost on me, that detailees from the USPTO are also a very important part of us getting to, I think, a good outcome in this Congress. We're back to the same thing. Strong, reliable, predictable IP rights are paramount to incenting U.S. innovation. This innovation which fuels economic growth of our great country, and innovation is critical to our national security. We want to encourage future inventors, big and small, to come forward and embrace our patent system. We also want to encourage interest in serving our patent system by encouraging the next generation of patent examiners, trademark examining attorneys, and trademark examining attorneys. We want to take a moment to thank them for all of their hard work. They're in the trenches and they've got a lot stacked against them. But I think our faith in the patent system has to exist at all stages of the patent's life cycle, from examination to potential litigation. That's why I introduced, along with Chairman Coods, the Patent Eligibility Restoration Act. I have a handout here suitable for framing. I'll let you be the first recipient so that we can start communicating this. We've pursued multiple avenues to encourage patent reform, but it's crystal clear that a legislative solution is necessary to provide an appropriate patent eligibility framework to ensure the future American innovation and American leadership in the world is secure. U.S. patent eligibility law has become confused, constricted, and unclear. It has led to inconsistent case decisions, uncertainty in innovation and investments, and unpredictable business outcomes. This bill, I believe, restores patent eligibility to important inventions across many fields, such as medical diagnostics, biotechnology, personalized medicine, artificial intelligence, 5G, and blockchain, to name a few. This will ensure that the U.S. remains the world's innovation leader in the years to come. To help support U.S. innovation, I also joined Chairman Coons on the PREVAIL Act. We'll get you one suitable for framing too, which is also good, sound policy worked out on a bipartisan basis. When properly constructed and administered, the PTAB can play a vital role in maintaining strong, reliable, and predictable IP rights. However, the PTAB has been subject to practices that have been abusive and open to gamesmanship. While a number of policies have been put into place to crack down on abuses at the PTAB, practices can be changed with each new USPTO director. That's why I think legislation is necessary to codify some of these reforms, to provide long-term stability and certainty at the PTAB, and to permanently end some of the abuses that we've seen in the past. So, Mr. Director Vidal, thank you for being here. Thank you for being here. And I look forward to your testimony and our continued partnership as we move forward. Thank you.
Thank you, Senator Tillis. Ranking Member Tillis, I'd like to turn to our witness. I'll offer a brief introduction, if I might. Today, we welcome the Honorable Kathy Vidal, Undersecretary of Commerce for Intellectual Property and Director of the United States Patent and Trademark Office. In addition to leading the PTO, Director Vidal serves as the principal advisor to the Secretary of Commerce on both domestic and international IP policy matters. Prior to joining PTO, Director Vidal served as managing partner of Winston & Strawn's Silicon Valley office, where she represented clients ranging from large and well-established companies to small startups in patent litigation. Earlier in her career, she led Fish & Richardson's litigation group of 270 attorneys in 11 offices worldwide. Previously, Director Vidal was an engineer for both Lockheed Martin and General Electric, working on aircraft and engine control systems before going on to pursue a career in IP law. Director, after I swear you in, you're going to have 5 minutes for an opening statement. Then we'll proceed to questioning. Each senator gets 5 minutes. We'll likely do a second and even a third round, just depending on attendance and timing. Director Vidal, could you please stand to be sworn in? Please raise your right hand after me. Do you swear or affirm that the testimony you're about to give to this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, Director Vidal. May you proceed with your opening statement.
Thank you. Chairman Coons, Ranking Member Tillis, and members of the subcommittee, thank you for this opportunity to discuss the great work the United States Patent and Trademark Office, USPTO, is doing. I must start by thanking you for your unwavering commitment and focus on our IP ecosystem. I am confident that together we can shape IP policy and practices to be an even greater catalyst for job creation and opportunity in each of your states and across our great nation. In addition to the transparent, data-driven, and surgical changes we have made and intend to make this administration to better support our stakeholders and the issues they face, there are a few key areas of focus I'd like to highlight. First, the USPTO, like you, is focused on AI, including as related to patent protection and the copyrighted works that drive so much of our economy. I am working with the White House, the rest of Commerce, the Copyright Office, and across government on AI policy, and see it as one of our greatest challenges and opportunities. Second, as you well know and have said, we need robust, reliable, and transparent IP rights and efficient and effective enforcement, not just here but across the globe. The USPTO is working globally to strengthen the innovation, creativity, and entrepreneurship ecosystem, to hold competitors to their agreements, to curb abuses and unfair practices, and to directly assist stakeholders facing IP issues abroad. At home, we are ensuring that the patents we issue continue to incentivize innovation and the trademark register is accurate so that businesses can assess and rely on those protections of our trademark laws. Third, we are working across government on the intersection of IP and competition policy, including as related to standards, to promote a strong IP ecosystem while maintaining the U.S. as an entrepreneurial nation that promotes startups, small businesses, and small enterprises. We are collaborating with the Food and Drug Administration and the United States Department of Agriculture to take into consideration the needs of small family farmers and the concerns of patient advocacy groups. Fourth, the USPTO is committed to an all-of-government approach to leveraging IP rights to catalyze U.S. economic competitiveness and national security. We are doing that inclusively and forming the partnerships, relationships, and alliances that will help us reach every corner of our country, including our schools, our military spouses, and veterans, as well as opening new outreach offices under the Unleashing American Innovators Act passed by Congress last year. Mr. Chairman, I am honored and proud to be a part of the USPTO, an incredible agency with dedicated and knowledgeable public servants. As a steward of the agency, I must add, as a fifth and last point, that we are also working on reshaping the USPTO as a workplace centered around the values of purpose, opportunity, equity, inclusion, and wellness to better serve the American public and stakeholder community. We are innovating America's innovation agency. We cannot do all we are doing without your collaboration. The USPTO is grateful that Congress continues to provide it with fee-setting authority, which enables the USPTO to continue to build, retain, and effectively manage its workforce. We look forward to working with this committee to ensure USPTO maintains that authority. In closing, we look forward to continuing to work with you and alongside you to use our intellectual property system to grow jobs in every community and to foster economic prosperity and innovations that will benefit all across our great country. Thank you again for the opportunity to testify today, and I look forward to your questions.
Thank you, Director. I appreciate your update on the USPTO, its operations and processes. I'm going to start by exploring the importance of a reliable and effective patent system, as well as PTAB reform, and then in a second or third round, we'll talk about patent eligibility as well as counterfeit goods and other issues. In January, the ITIF issued a report entitled Wake Up America that found China is likely to overtake the U.S. in innovation and advanced industry output. What patent system reforms do you think should be part of a meaningful and effective strategy to ensure we maintain our competitive edge in global technology leadership?
So first of all, thank you for that critically important issue. That is one of our main areas of focus. I will say there is a lot of work that the USPTO is doing right now in view of stakeholders' concerns regard to China. Part of it relates to counterfeiting, which I know we will take up later. Part of it relates to ensuring that U.S. companies have fair treatment in China, or at least at a minimum, get the assistance from our IP attachés and our China group as they navigate China when it comes to intellectual property. In addition to that, we at the USPTO have been engaged interagency with the rest of government to deal with Chinese threats. We've also been engaged with the IP office and with government in China to hold them to the commitments that they've already made to the United States. And regularly, we're involved with engaging them on new reforms that they may be proposing within China to make sure that our stakeholders' views are considered alongside that.
Let me mention one of the efforts that I've undertaken with Senators Tillis and Hirono and Durbin, the PREVAIL Act. It's a bill that includes measures to align the PTAB and its practices with congressional intent to have an alternative to litigation to decide validity of a patent. Your ANPRM, your advance notice of proposed rulemaking, includes several proposals that overlap with that bill positively. I was pleased to see that, but several of your director review decisions and guidance on how the PTAB ought to exercise discretion on institution, on beginning a patent validity review, have narrowed practices that previously helped curb multiple attacks on the same patent. Some of the ANPRM proposals indicate similar direction towards policy reversals. Is the office seriously considering rolling back these previous improvements?
The intent behind the ANPRM is to, number one, memorialize some of the efforts that are working productively, including on serial and parallel attacks. We recently did a study on serial and parallel petitions, which shows that the guidance that we've offered, the precedential decisions that we've offered, they're working. And so part of the ANPRM is to memorialize that. The rest of the ANPRM has proposals that came out of stakeholder feedback so that we can gather additional data in deciding what to move forward with and what, importantly, not to move forward with. So those are not, per se, proposals from the USPTO in terms of what we believe are the best avenues for moving forward. It's more an attempt to gather additional data so that we can either move forward with some of the proposals or variations of the proposals.
Would you just, as a matter of sort of general principle, agree that if you've got a proceeding in the district court and the PTAB at the same time covering the same topic, addressing patent validity, that doesn't really fulfill congressional intent for the PTAB to be an alternative and more efficient forum for patent review?
We hear that very often from stakeholders, Senator.
And can you share with me what your views are on that?
So my views are going to be informed by the responses to the ANPRM. I do think that there are concerns with overlapping proceedings in the PTAB and with district court in terms of where the USPTO draws that line, whether we continue on with offensive guidance, whether it's whether we evolve that in some way to better serve stakeholders and better serve the intent of the AIA. My views on that will be informed by the responses to the ANPRM.
You got over 14,000 comments to the NPRM, which speaks to the degree of awareness and engagement. And I think PTO regulations can address some of the concerns that I hear about PTAB. Do you have a sense of timeline for when you might issue a notice of proposed rulemaking and then be able to implement a final rule?
In terms of the timeline, we are working on the NPRM now. There may be two of them. We haven't decided whether to put everything in one package or, given the breadth of the ANPRM, whether we break it up into two NPRMs, one more procedurally focused and one more substantively focused. So we're still in the process of analyzing that and analyzing the comments. We realize that we need to move as fast and as possible while being very deliberate about what we're doing moving forward. I do plan soon to announce some of the initiatives that we will likely not move forward with so that we can keep everybody's focus on the initiatives that we do plan to move forward with.
One potential way to address some of the issues in PTAB that's in the Prevail Act is a standing requirement for inter partes review. It's my concern, anyway, that there have been a significant number of companies formed specifically just to attack patents that have already received district court damages awards. You've taken some steps to address this, which suggests you may share these concerns. How would just broadly speaking, how would implementing a standing requirement help address some of the current abuses at PTAB?
So in terms of a standing requirement, that is something that stakeholders have brought to our attention, that they believe that will help, that what we're seeing in terms of practice before the PTAB is when the parties do have what would be, might qualify as a standing requirement, their activities tend to align with their business purposes. When parties don't have what might be a standing requirement, we've seen parties take advantage of the system. There have been recent instances of that where the parties are trying to monetize and otherwise use the PTAB process for personal gain as opposed to its original intent.
Well, thank you for your testimony so far. I look forward to our second round of questioning, and I'll defer to my ranking member, Senator Tillis.
Thank you, Mr. Chair. I think the patent system works best when there's clear rules of the road to guide inventors and businesses when they're considering obtaining a patent and protecting the fruits of their labor in research and development. Following a series of Supreme Court cases, though, one critical requirement for obtaining a patent, whether a patent is eligible in the first place for patent protection under 101, has become the opposite of a model of clarity, in my opinion. So I know you stated during your confirmation hearing that you thought that more clarity around Section 101 would be helpful. Do you still think that's true?
I do, Senator Tillis, and you will see that view articulated in the government brief in the Trop and Interactive Wearables case, where we set that forth. You'll also see it in the 2022 report to Congress, where in both of those we articulated that we do need a very predictable, reliable system in order to encourage investment, in order to encourage the fruits of labor that result in innovation, and in order to bring products to market. We need a system that the public can rely upon when they get an IP right.
Can you cite any examples of work that you're in process of or work that you've done to try and help on this issue already within your authority?
So one example is our engagement at the Supreme Court level with the Department of Justice. We work very closely with them on these issues. We are also trying to identify other mechanisms within the judicial system to bring more clarity when it comes to 101 law. In addition to that, the guidance, the 2019 guidance and the additions that we've made under my tenure provides at least some certainty within the United States Patent and Trademark Office in terms of whether somebody's able to obtain a patent. We issued a request for comment on that guidance to receive feedback on whether we should modify that guidance. We have not made a final decision on whether to modify that, but we continue to provide additional training based on cases that we're seeing. But as you may recognize, within our purview, there's only so much that we can do.
What about I have a belief that Congress probably needs to do something too. Do you have any opinion on that? I know you're not telling us how to implement policy, but what sort of enablers or things that we should be thinking about, and anything you may have heard that wouldn't be particularly helpful?
So I want to commend the attention that you've placed on this area of law. To me, it's one of the critical areas that we need more clarity in to really have a more robust economy and to incentivize innovation. As you recognize, if Congress were to step in, you could really impart the clarity that's needed that would take perhaps much longer through other mechanisms.
Mm-hmm. I know you haven't, and it may be a matter of policy, you haven't taken a position on any of the bills that we're proposing, but not necessarily expecting a response here, but I would be very interested in engaging with the office if there are any concerns with it to get to a point to where you all are comfortable that what we're doing on the legislative front is matching with what you believe is an enabler will help us get to where I think we both want to be. I'm going to wait and ask a couple of other questions in a second round, Mr. Chairman, but I did want to reemphasize the counterfeit goods. One of the hearings that just sticks in my mind, I ride mountain bikes, and it's like cars and everything else. Everybody has their preferred products. I happen to use specialized equipment. And I saw a relatively small person take about a 1 foot step in the air and absolutely crush a helmet on that floor. That was counterfeit. I've broken in my mountain biking. I'm better than this may suggest, but I've broken 2 helmets mountain biking. And if it had been one of those helmets, I probably wouldn't have made it. And we need to really do a better job, I think, of educating the American public that whether it's batteries, it's safety equipment, the Chinese are willfully allowing companies to counterfeit products, send them here, sell them at the same price point, and potentially creating life-ending consequences as a result. So I look forward as we have future hearings to shine light on that. I yield back, Mr. Chair.
Thank you. Senator Tillis, Senator Hirono.
Thank you very much, Mr. Chairman. Ms. Waddell, it's good to see you. A recent World Intellectual Property Organization study found that the U.S. lags behind China and much of the world in our efforts to fully mobilize the inventive talent of our nation's women. Recent reports by the National Bureau of Economic Research and Citigroup estimates that closing our racial and gender patent gaps would add $1 trillion to our annual GDP. This is to say nothing of the growth that could be unleashed by expanding opportunities to underserved geographies and veterans. Unleashing this potential is why we passed Senator Leahy's Unleashing American Innovators Act last year. And Mr. Chairman, I ask unanimous consent to place a letter Senator Leahy sent to me about the importance of that legislation into the record.
Without objection.
Unleashing our country's full potential is also why last Congress I worked with Senators Tillis, Coons, and other colleagues to introduce the IDEA Act, which directs the PTO to collect demographic information that patent applicants submit on a voluntary basis, so that we have data to rely upon as we make certain decisions. So my staff is now working with you, with your staff, on some technical changes to the bill that I referred to, and I hope to reintroduce it soon. Can you speak about how important it is to unleash our country's full innovative potential, meaning women and minority persons?
Thank you for that question. That is a very key focus of mine through the work that I'm doing for the Council for Inclusive Innovation, to the work that I'm doing across the United States Patent and Trademark Office. I am focused on that for the very reasons that you note, that not only is it a matter of equity, it's a matter of it's a national imperative that we do this. It's going to unlock innovation. In terms of demographic information, I agree that collecting it would be extremely helpful to inform our policies, to inform our actions. That is why, in view of the act that you introduced, I've been working separately at the USPTO to find ways to be able to satisfy the Paperwork Reduction Act requirements while still being able to collect that data. So we are working in parallel to try and make that happen.
Do you have any specific kinds of programmatic changes or whatever you're pursuing to, for example, focusing on women to submit their patents?
I do, Senator. The Secretary of Commerce and I founded the Women's Entrepreneurship Initiative, and through that initiative, we are working to help women across the country learn about the innovation ecosystem, learn the value of intellectual property, and learn the resources that we have available. That is everything from trainings that we offer to pro bono help if they're under-resourced, to our pro se offerings where if people are filing on their own, we provide additional assistance. So we are trying to provide all of that information. In addition to that, we're trying to figure out where women might opt out of the process. We have seen studies that suggest that when women receive a rejection letter as part of the patent process, they are more likely to opt out than men. So we are creating additional language around that. We are creating cover letters that welcome people, everyone, not just women, to the United States Patent and Trademark Office, that let them know of the available resources and that encourage them on their way and really put some of these objection letters and final rejections into context so that they will persist in obtaining patent protection.
We were told the story of Sarah Blakely, the inventor of Spanx. She talked about how she had her invention, and she went to all these male attorneys to ask them for help in patenting it, and they basically laughed in her face. And it was when she went to a female patent attorney that she was able to patent her product, her invention. So I think that the idea of expanding and diversifying, it runs across all gamuts, including lawyers, you know, to be able to know a product when they see it. But when it comes to diversifying the ecosystem for patents, we really have to be intentional about it, and whatever you can do to get across to women in our country, girls in our country, that they can invent things and that they can be part of a huge economic make a huge economic difference to our country. So I'd like to continue to hear what you're doing and be as supportive as I can be.
May I address that briefly?
Yes.
So I do want to let you know that in addition to the efforts that I explained, we're also broadening the bars to practice before the United States Patent and Trademark Office. Mm-hmm. We believe that will have an impact on diversity as well. We're broadening the patent bar. We are in the process of setting up a design patent bar so that people who do not have electrical engineering degrees can still practice before us if they're practicing in the area of design patent protection. And we're also looking at broadening the PTAB bar.
Thank you.
Thank you.
Thank you, Senator Hirono. Senator Padilla.
Thank you, Mr. Chair. On April 21st, the Patent Office published an advance notice of proposed rulemaking that proposed substantial changes to the rules governing administrative review proceedings before the Patent Trial and Appeal Board. To say that this rulemaking is of intense interest to many of my constituents would be a dramatic understatement. Ms. Vidal, as you noted in your testimony, there were over 14,000 public comments from stakeholders, which I understand to be an unusually large number. I know you responded earlier to questions from the chairman that spoke to not just a large number, but thoughts on how to address many of the concerns expressed in that public comment, pathways forward, and the timing of proposed rulemaking. So I won't be repetitive with those questions, but I do want to also acknowledge our former colleague, Senator Leahy, who recently wrote 2 op-eds critiquing the rulemaking as exceeding the Patent Office's statutory authority and conflicting with the America Invents Act. And I'll quote from Senator Leahy. He says, "I can say with absolute certainty that the proposed rules directly conflict with the legislation on a variety of matters, especially on provisions that limit access to the PTAB." And he points to the proposed standing requirements for PTAB proceedings and shortening the deadline for filing a petition for review from 1 year to 6 months. So just given that and more of the concerns I'm sure you've heard, wanted to afford you an opportunity to respond to those viewpoints.
Thank you, Senator. In terms of what was in the ANPRM, they all fall within the USPTO's authority, including those under 35 U.S.C. 2B, 2A, 314A, 316A2, A4, A6, B, 317B, 324A, 326A2, A4, A6B, and 325D. That said, it is not clear that we are moving forward with all of those proposals. As I mentioned earlier, the proposals in the ANPRM serve two purposes. Some of those proposals really codified our existing practices, which we've received positive feedback on and which are actually becoming very effective. And they provided the option for stakeholders to suggest changes to those existing practices. The other proposals in the ANPRM were ones that came from stakeholders, and instead of the USPTO making a decision without data, we decided to float all of those in the ANPRM so that we could receive data from stakeholders and determine what to move forward on. So in terms of where we're going from here, we do I plan to release something soon on what we have decided based on the comments we're not moving forward on, so that people can focus on the areas where we are planning to potentially make a difference, and then we will move forward with the NPRMs on those topics.
Okay, that's helpful. Thank you for that.
Thank you.
I also wanted to ask a follow-up question on something Senator Hirono raised, and that's the value of diversity in inventorship. She spoke to gender and ethnic diversity. Research has also found that inventors are becoming increasingly geographically concentrated. A National Science Board found that in 2020, 41.6% of U.S. counties had 0 patents granted to people residing in that county. And as representative of California, I know that the general Bay Area and the Central Coast appears to be very well represented in terms of patenting. The Central Valley of California and other regions in our state, for that matter, are not. So could you speak about the importance of meeting potential inventors where they are, with research showing that inventors are increasingly concentrated, as I mentioned? What steps are we taking to extend participation in inventing and patenting in communities across the country?
I'm very focused on that issue, and I'll just tell you some of the things we've done already. So I brought together our regional offices in Colorado in July to talk about how we could better use the regional offices to have more reach within the regions. Beyond that, as part of our Council for Inclusive Innovation, we're starting an IP Ambassadors program so that we can use all of our great employees in every state. I know we have 385 employees in the state of California dispersed throughout the entire state. They could then work as ambassadors and work with communities to be there and support innovation. In addition to that, we have patent, trademark, and resource centers and libraries around the country. I've started sending individual letters to each of the libraries where we don't have a PTRC and asking them to join the PTRC program so that we can bring patent and trademark resources into communities. I immediately got a response from Virginia Tech, who signed up immediately. They're a minority-serving institution, and so I'm looking forward to doing more and to making sure that I'm reaching every university that has a library, including community colleges and ones in remote areas, so that we can bring those resources to them. That's just a little bit of a flavor for the work that we're doing, but we are very adamant that we need to get everywhere, including, I will note, to military bases. I'm going to military bases across the country, and I'm going to Delaware soon. I've been to North Carolina. I've been to a number of states, not hit California yet, but I've been to Hawaii and met with military bases, worked with the schools on innovation training, worked with the military service people, their spouses, veterans, on how to be part of the innovation ecosystem.
Okay. Well, you have an open invitation to come to California. Look
Yes.
forward to welcoming you there.
I get there once in a while.
Thank you, Mr. Chair.
Thank you, Senator Padilla. Senator Welch.
Thank you very much. There are no two stronger champions of the intellectual property rights of innovators and patent holders than the two leaders of this committee, Senator Coons, Senator Tillis, and I support your efforts in that respect. I do have a different concern that I want to talk about. It's really important, your responsibility to have patents issued timely, appropriately for innovators. It's your responsibility to help enforce those patents so that the innovators get the benefit of the intellectual property that they created. But what I've seen is, in particular in the drug industry, an abuse by patent holders of that period of exclusivity. That is an extraordinary benefit that is provided to the innovator who comes up with a drug. They get a period of exclusivity, essentially monopoly, and it involves something that is absolutely essential and vital to the well-being of American citizens. But as you know, many of these patent holders then use devices to extend that period beyond the original grant of exclusivity. I just want to give an example of AbbVie and Humira. That period of exclusivity was supposed to expire in 2016. In Europe, it did. But by creating a patent thicket and using the term of art that AbbVie in its own documents used, a patent estate, they were able to create litigation obstacles to biosimilars and competitors coming on the market at the time that their period of exclusivity ended. And what that meant, I'm just showing this chart, 2016, this is what the price was of the Humira, $1,870. They've extended the patent all the way through 2023. It's now almost $3,200. During that time, there was an extra cost to U.S. taxpayers and folks who are purchasing health care of $19 billion, $100 billion in additional revenue. And where you have a patent system that can be abused by the patent holders and they go beyond the period of exclusivity, it's brutal on the cost of health care for American employers who are providing health care through employment, to taxpayers through the Medicare and Medicare program, and to private payers. Humira in the U.S. is $3,000. Right now in Sweden, it's $225. $10 in Germany. So the question I have, and I'm sure this is a concern to you, is what is the ability and the commitment of the Patent Office to stop the extension of that period of exclusivity and monopoly power that has been so consistently abused by the drug companies to rip off American taxpayers, American employers, and American consumers?
Thank you, Senator, for shedding light on that critically important issue. As you know, President Biden has made lowering prescription drug prices in America a key.
This is lower. I want to know what you see as the obligation of the Patent Office to not, on the one side, protect the patent rights of the intellectual property holders. I get that.
Yep.
But the abuse by the patent holders to extend beyond the period of exclusivity so they can rip off American consumers.
So I can let you know what the USPTO is doing in that regard. Certainly patents cannot be extended themselves, the actual patent, unless there's a patent term adjustment. We are looking into those patent term adjustments. Indeed, our Office of Patent Quality Assurance is reviewing applications that have the highest risk for unwarranted extensions of the patent term. In addition to this, we issued a request for comment for robust and reliable patents to get feedback on what more we can do, including with regard to obviousness type double patenting. That is one of the reasons that U.S. patents can continue to issue where they don't in other countries.
Let me just ask
Yes.
this. I don't get it where you get a patent, let's say, for 20 years, and it goes on for 30 years or 35 years. I mean, 20 years is easy enough to figure out. That's when it should end. And there's got to be some capacity on the part of our system to deal with that extension abuse. So I'd really welcome some concrete suggestions or legislative proposals you think may make sense to enable you to enforce that side of the patent exclusivity period. Thank you.
Thank you.
Yield back.
Thank you, Senator Welch. I'm going to yield to Senator Tillis for the first of a second round of questions because his schedule requires him to depart relatively soon. Senator Tillis.
Yeah, thank you, Mr. Chair. I've got to go to Veterans Affairs committees, but I want to thank Mr. Welch. Senator Welch, we've had several different discussions about how we go about attacking and creating a sustainable change in the trajectory of drug pricing in this country. There's a markup just got completed. and finance, which I think is critically important. It relates to the PBM's contribution to the escalation of costs. So I look forward to working with you. My question, it wasn't prompted by Senator Welch's, but my final question I wanted for you is I sent 2 letters to the USPTO about the findings published by the Initiative for Medicines, Access, and Knowledge, IMAC, on drug-related patents that appear to overstate the periods of exclusivity based on their analysis of relevant patent protection. I think one thing we've got to do here is just make sure that we're all talking from the same set of facts. If in fact this is true and there's data to support the fact that maybe this is wrong, I just want a good independent assessment of data so that when people quote a source, we know it's a reliable source. I don't think we've gotten feedback yet, but I was wondering if you could give me any update on the progress of our letter.
I appreciate that. That's one of the initiatives we're working on with the FDA. So that's a collaborative effort that we're working on with them.
Good. Well, I think that'll get our facts straight. My final question is just a simple one. I think you're doing a good job. I have a variety of reasons why I'm pleased with your work. I'm glad to support your confirmation. But what more do we need to be doing? This has less to do with the policy discussions that we were talking about here, but as you're looking ahead to the USPTO and you're looking support for Congress, something that's going to require either appropriations or authority, can you give me some insight, if any, into what you'd like for us to consider other than what's moving through this committee at this time?
Yes, certainly anything related to the USPTO's fee-setting authority would be very helpful. We also have approximately $1.3 billion locked up that we have not been able to get access to. Getting access to that money would let us move to updated IT systems, would help us enable our outreach. There's much we could do with that money without having to impose the fees on consumers. So I would say both of those are top of mind.
Good. Well, we'll keep those in mind, but just make sure you communicate to mine and Senator Coons' office on other things that we should be doing that just give you more tools to continue to improve. And I appreciate you being here today.
Thank you, Senator Tillis.
Thank you, Senator. And I know you and Senator Welch and others have a markup you need to get to. Thank you for working so collaboratively on this hearing. Director Vidal, I think we certainly agree that the current framework for determining which inventions are eligible for patent protection is just not working. We see remarkable developments in artificial intelligence and medical diagnostics. What changes, in your view, to the patentability framework would provide greater certainty to inventors around what can be eligible for patent protection?
In my view, and a lot of this was articulated in the Trop and interactive wearables case, we need more certainty and clarity. Right now, the biggest issue is that. Beyond that, certainly if there are categories of inventions like patent diagnostics, if those were singled out as areas that could be patentable, certainly that would also provide additional clarity.
I was struck the Federal Circuit held that the guidance that you offered was not binding on courts. I think an obvious implication of that is that Congress has to step in. Am I wrong? Can the USPTO take further steps to tackle patent eligibility that I'm missing?
Changing the guidance, I don't believe, would be of any help when it comes to tackling it at a higher level. Certainly that would control the patents we issue, but what happens with them when they leave our doorstep is beyond our control. So beyond that, we are engaged with the court system to try and make positive change there. Be more than happy to work with you and Senator Tillis's office on the proposals that you have out there and provide technical assistance on that.
Well, we invested a huge amount of time in trying to sort of square the circle of patent eligibility, and we intend to take another strong run at it and would be grateful for your close cooperation. The areas that are currently outside the ambit of patent protection have become more and more critical to our country, our competitiveness, our economy, and I'm afraid we are creating a critical vulnerability for our competitiveness. Let me talk about counterfeit goods for a moment, if I can. What's the Patent and Trademark Office doing to address the rapid proliferation of counterfeit goods, especially those marketed online, and what do you think Congress could do to address the sale of counterfeit goods online?
Starting with the second question, anything that Congress could do to create laws and create rules that would cut down on counterfeiting would be much welcomed. I'm very concerned about the effect that counterfeit goods not only have on our economy, same thing with pirated goods, have on our economy, but also, as you mentioned, on the health and safety of our people. In terms of what the USPTO is doing, you mentioned the Go for Real campaign. That's been a real successful campaign. We've also created online games that have been downloaded by 17,000 educators to educate them about counterfeit goods. We teach children through our Camp Invention, 280,000 children last year, about counterfeit goods and the dangers, and help teach them the reason why they want us to respect IP, because they have great ideas that they want respected. Beyond that, we work both domestically and internationally on policy. And we're going above and beyond when it comes to counterfeit goods. I made that clear as soon as I came on board that was something that I wanted to tackle. We just issued a Federal Register notice trying to find out from our stakeholders future strategies when it comes to anti-counterfeiting and anti-piracy, and what more the USPTO and U.S. government can do to help. We work with law enforcement agencies. We work with other countries to help set up infrastructures and laws within their countries. Even as I sit here today, we have over 50 judges from the Indo-Pacific region over at the USPTO engaged in dialogue with a judge on the federal circuit and other judges in the United States on issues like this, so that we can have a common ethos when it comes to counterfeit goods and the importance of IP enforcement as well as IP protection.
I have to say, Director Vidal, I am impressed with the range, the scope, the ambition of your outreach. Just because I'm not asking a question about inclusion and outreach, as Senators Hirono and Padilla and others have, doesn't mean I don't value it. It is a valuable part of the tireless work you're doing. The Shop Safe legislation that Senator Tillis and I are seeking to move would actually hold online platforms liable for harmful counterfeits unless they adopt a set of best practices. I recognize that's a step the USPTO can't take, and I'd welcome input or technical assistance on that. Let me just reference PTO fee diversion, something I've been passionate about for a very long time, because the PTO is funded with fees, not tax dollars. At different points over the last 25 years, more than $1 billion in user fees have been diverted to other government agencies from the PTO. I think giving the PTO rate setting authority is a key part of legislative engagement with the Congress. How important is it for you to be able to keep all of the fees that you collect? And have you given any thought to whether or not changing the fees for IPRs, for PTAB proceedings, so that they at least capture your actual costs, might also make sense as a way for you to, I mean, it seems odd to me for inventor application fees to be subsidizing, to some extent, challenges to those very patents.
Well, I appreciate the feedback on the IPR and PTAB fees. We are going through fee setting right now, both on the patent side and the trademark side. So that is something that we're looking into when it comes to those fees. In terms of how important it is for us to keep all our fees, we are not funded by U.S. taxes. So in order for us to operate, in order for us to bring down pendency, to be innovative and creative, and to stay agile, which is especially important now as we're seeing artificial intelligence in over half of our technology groups and patents, and we're seeing new scams on the trademark side of the house. We really need the ability and flexibility to be able to allocate fees and allocate our workforce so that we can keep on top of the most pertinent issues at the time.
I must say, I am struck by the reach of some of the trademark scams. My folks shared with me a scam in which a Chinese company filed 2,000 trademark applications under the name of a dead American lawyer. You've certainly warned about scammers calling trademark holders, impersonating examiners, demanding payment not to cancel registrations. What more could we do together to identify fraud and make the trademark registry cleaner, better, more accessible, but also more protective for legitimate rights holders?
I'm happy to take that back to my team and talk to you. I know that every time we see something, we make changes. So in view of the latest scam, which is, as you mentioned, is people impersonating the USPTO and watching when trademarks are filed and immediately reaching out and say, if you want to get your trademark, you have to pay us money. We are now putting a cover letter on trademarks as well. I don't believe it's gone out yet, but we've crafted one that lets people know that we are not going to ever call them and ask for fees. And so we are always, it's a little bit like whack-a-mole. We're always trying to figure out what's the best response and how quickly can we put it into effect. And then also, as you recognize, we communicate with our stakeholders directly and try and get the message out. But it's just really important that we inform our stakeholders and then take any action we can. We've taken a lot of actions with regard to sanctions, with regard to sending lawyers to our Office of Employment, Enrollment and Discipline, and we're doing everything we can at every stage, and we're investigating all of these types of activities to make sure we stay on top of it. But to the extent that we might be able to work together on that, I would love to talk to the experts in my office and see what great ideas they may have.
Thank you. This is my last question. Our first subcommittee hearing was on foreign competitive threats to innovation, and it highlighted China's abusive practices with a particular focus on standard essential patents, or SEPs. Given that ongoing challenge, that abuse, I've been following with genuine concern recent proposed regulations by the European Union for what would essentially be an SEP rate court. That regulation, I'm concerned, validates China's practices that have also harmed U.S. patent holders. And I have shared those concerns with Secretary Raimondo during an appropriations hearing, and she agreed the proposal is problematic. What steps has the USPTO taken to communicate concern to our European colleagues, and what steps do you think the administration can and should take to guard against restrictions on SEP licensing in the EU and globally?
As I mentioned in my opening remarks, that's one of the things that I'm keenly focused on is standards, because I think it's critical to our economy. I will say that when we withdrew the 2019 policy statement around SEPs with NIST and DOJ, it was because we see standards as an international issue, that individual countries weighing in these ways could be extremely problematic. So what we've done when it comes to the EU directorate is I've met with the EU IPO in Geneva just a week and a half ago. I've also spoken to other stakeholders in Europe about this. We also are issuing soon an FR notice, a Federal Register notice, to seek feedback from U.S. stakeholders on international SEP policy so that we can inform an all-of-government approach. That's going to be not just the USPTO. I'm doing that with NIST, our Standards and Technology Group, and ITA, our international group within Commerce, so that we can get an all-of-government approach to this that's data-driven by feedback.
Well, Director Vidal, I appreciate your participation today. Thank you for your perspective and the work that you're doing on all the folks at the USPTO to promote and protect innovation. I'm grateful to the members who were able to attend, and in particular to Ranking Member Tillis for being a great partner. We will continue to hold hearings as the year goes on some of the more thorny issues that we explored today, patent eligibility, PTAB reform, and others, and we welcome your partnership and engagement as we move forward. I think we do have a genuine opportunity for bipartisan progress in this Congress, and we're going to work hard to achieve that with the legislation I referred to, Prevail, PARA, and others. Just for the record, members may submit questions for our witness. They're due 5 p.m. 1 week from today on August 2nd. I want to thank you again for participating today, Dr. Vidal, and very much look forward to continuing to work with you. And this hearing is adjourned.